The following audio recording has been designed for learning purposes only. Do not share, distribute, or provide any type of copies, or this audio lesson will not be made available to you. Good luck with today's lesson.
We're going to cover decedents' estates and trust. At the time of an individual's death, his or her obligations must be satisfied and their property distributed either according to the desires they express in their will or by the provisions for intestate succession, which takes effect when a party dies without a will. The Uniform Probate Code is a statute seeking uniformity on the administration of estates and wills. So what happens if someone dies and that person has left a will? If the decedent has a valid will, the person has died testate. If, however, the decedent doesn't have a will, that decedent is said to have died intestate. Now, a will is made by a testator or a testatrix. Historically, testator meant it was a male, and testatrix was a female who was making that will. And if the gifts were made under the wills as legacies, devices, or bequests to legatees or devisees. To create a valid will, the testator must have had testamentary capacity, which is the ability to understand the significance of the will and the beneficiaries of the gifts made thereunder. Think testamentary capacity is similar in a sense to contractual capacity. In contracts, we said, did you have the capacity to understand the terms that you were agreeing to in the contract? And here it's, do you understand what you have? Do you have that testamentary capacity? So think of the testamentary capacity being, do you understand what your will is going to, that you are writing this will and that you are going to be executing in a will and what that entails? Now, state statutes specify the form of a will, and most will require the will to be in writing, signed by the testator, and attested to by the statutorily required number of witnesses. Most states will require 2 witnesses. However, there are some states that will require 3 witnesses. When we're in Michigan, we do have to have 2 witnesses. Generally, what you do is you get disinterested parties. So you really don't want like your child being a witness to the will because they're the majority of the time going to be interested in what happens upon your death. Okay. The will can also be modified by a codicil or revoked. However, the act of revocation must be clear in terms of the testator's intent. A will can also be revoked by operation of law as when there is the birth or adoption of a child. The surviving spouse may ignore the provisions of the will and elect to take against it. When the surviving spouse does this, the surviving spouse will receive the share of the estate she would have taken had the husband died intestate, or may receive a fractional share specified by statute. A decedent may also disinherit a person from his will. So let's say son continuously has borrowed money from the father all the time, and he's bailed him out of things, or maybe they just had a falling out. The decedent, the father, could specifically write him out of that will and disinherit him and say, nope, I've given him whatever while he was living, and therefore he gets nothing else. Or maybe he just, again, had a falling out and he just chose to write him out of the will completely. Now, there are 2 types of wills that are special types of wills. We have holographic wills, and then you'll hear living wills. A holographic will is a will that is written entirely in the testator's hand, and there are not any witnesses. In order for that holographic will to be valid, it requires that the testator signed it and that all the material provisions are in that testator's handwriting. It will also be dated. Generally, you don't want to sign the wills at the top of the page too. You usually want to sign them at the bottom. A living will is a document where an individual specified that he doesn't want life-sustaining medical treatment if he is in an irreversible, incurable condition. So you can see living wills are not really wills pertaining to who gets your assets and stuff. A living will is pretty much saying, don't resuscitate me if something were to happen to me while I'm in the hospital, if maybe I'm in a coma and there's no way I'm ever going to come out, something like that. So living wills are not wills in the sense that you are telling them what to do with your property. You should be aware that the person named in a will to handle the estate is going to be known as an executor or an executrix. Again, executor means they're male, executrix was referring to a female. When the person fails to name a person or doesn't have a will, the law will allow for another person to obtain an appointment. This person is going to be known as an administrator or administratrix. The UPC, our Uniform Probate Code, refers to administrators and executors as personal representatives. Now, probate is the process whereby the court accepts the will and then conducts the administration of the decedent's estate. If the will is contested, the court must first conduct a trial or hearing to determine whether there was a lack of mental capacity, undue influence, duress, fraud, or forgery. If any of these problems are found, the will not be admitted to probate and the estate will be distributed under the intestacy statute. The order of distribution of an estate is specific legacies, then general legacies, and then residuary properties. In the event that an estate is insufficient for purposes of paying their creditors, the creditors take from the distributions in reverse order. So they'll do then the residuary property to general legacies and then specific legacies. If property is sold or given away by the testator prior to death, the bequest is deemed or canceled. If the beneficiary in a testator's will has predeceased the testator, the gift does not lapse. Now, anti-lapse statutes permit the gift to go to the decedent's beneficiary's heirs. A surviving spouse may also elect to ignore the provisions in the will and take his or her statutory share. Such an election is generally made when the statutory share provides the spouse with more. With exceptions for surviving spouses, testators can disinherit relatives. Let's talk about what happens when the decedent dies without a will. If the decedent dies without a will, the state statutes on intestate distribution take effect. The statutes here can vary from state to state, but generally what happens is it will proceed in the order of surviving spouse, then lineal descendants. If you don't have any surviving spouse or any lineal descendants, then they'll go up the chain and say, well, do they have any ascendants, parents? And then they'll look at collateral heirs. There are various means of distribution, including per capital, which is equal, and per stirpes, which is by degree of relationship. If you kind of look on page 1076 of our textbook, you will see a sample of a per capita chart with a per stirpes distribution. Also, if you kind of backtrack and look on page 1071, that shows you an idea of what a living will looks like. When I said living wills were different from holographic. Now, there are some prohibitions on inheritance, including the murder of the decedent by the beneficiary. The administration of the estate is handled by an executor or executrix if the decedent had a will, we said, and the administrator or the administratrix if the decedent does not have a will, and by a personal representative under our Uniform Probate Code. An administration of an estate is not necessary if the decedent's estate is very small or the property was held as joint tenants with a spouse. So if you think back to when we did property in blaw 1, you heard of tenancy by entirety. That's when you got it at the same time, same interest, same possession, same title, and you were husband and wife. There, upon your death, then the property would automatically transfer to the survivor. Creditors will submit proofs of claims when we're going through probate and stuff, and their debts are paid prior to distributions. The other area we're going to look at when we're dealing with someone who happens to pass away is a trust. And a trust is going to be a legal device by which real or personal property is held by one person for the benefit of another. The party who's creating the trust is the settlor or truster, and the administrator is going to be the trustee of the account, of the trust account, I guess. And the party who's entitled to benefits is going to be known as a beneficiary. The property in the trust is called the trust corpus or res. The trust has principal and income, and expenses are allocated according to their nature. Now, a trust can be created while the truster is alive, which would be an inter vivos trust, or it could be by the truster's will, which would be a testamentary trust. If you do an inter vivos trust, generally those are going to be revocable as opposed to irrevocable. So then you can modify and change things as needed. The legal title to the res is with the trustee, and the beneficiary will have equitable title. A spendthrift trust will prevent the beneficiary from assigning his or her interest or rights to creditors. Now, trustees have several duties. They have the duties of due care, loyalty, and accountability. A trust can be terminated by its terms because of impossibility, by revocation of the settlor, by merger of legal and equitable title, or by request of beneficiaries when the settlor's desires are not compromised. I'd like you to take a moment, pause the audio, and go ahead and try and work on problems 2, 6, 11, and 15 in the back of the textbook on pages 1082 through 1084. Again, look at problems 2, 6, 11, and 15. After you took some time to look at those problems, then go ahead and restart the audio back up to see if you are on track on how you answered them compared to what the actual result is. Well, let's see how you did. In number 2, the question asked you, what should the court do with the will and the challenge to it and why? And here the court held that there was sufficient mental capacity. The mind need not be in perfect shape and the disposition logical in order to have testamentary capacity. And thus they held that the evidence was legally sufficient to support the jurors' finding of testamentary capacity. Now let's go take a look over at number 6. And the question that you were asked there was the signature sufficient to to allow this writing to be admitted to probate as her will? So what did you guys find? You should have found no. The will must be signed at the end. Signing on the envelope was not signing at the end, even though in point of time it might have been the last thing she did. Our next question I had you look at was number 11, and this dealt with revocations of wills. So here you were asked, actually, let me turn the page, who is correct about the revocation and why? Here you should have found that the implied language of the Florida statute required the intention of destruction of the original will or codicil in order to constitute a revocation, and the court affirmed the judgment. The law requires that the testator destroy the document that has been executed according to law. What the testator destroyed here was a document that was an exact copy of the fully executed original codicil and was in all respects identical to the original except for the original signatures. Because the testator destroyed a copy of the codicil rather than the original codicil, his attempted revocation was ineffective. A revocation by the act of the testator can also occur by the creation of a subsequent testamentary document if that document declares the earlier will or codicil to be revoked. However, if the subsequent testamentary document does not make this declaration, the subsequent document only revokes the prior will or codicil to the extent that it is inconsistent with the newer document. And finally, your last question was 15, and the question was, is Jeffrey entitled to receive the accounting? What could a court do in order to obtain the accounting? Here, the trustee is always obligated to account to the beneficiary. In this case, particularly because the father was a lawyer, the duty was beyond just that of a trustee. And the court found that the father was in civil contempt. They sentenced him to serve 3 days in jail, and they ordered him to pay son's attorney's fees. The Court of Appeals did affirm that holding of the lower court. Please let me know if you have any questions.
Good luck with today's lesson.